story that we've been tracking since yesterday, all week in fact. In a landmark move to tackle the recurring menace of bad loans, the President signed off on the ordinance to tweak the Insolvency and Bankruptcy Code. The changes, which were approved by the President on Thursday, come with a big twist. It's not just willful defaulters and those convicted of fraud. Defaulting promoters in general are set to lose their companies. The law does not mince its words or beat around the bush. It reads, and I quote now, "In order to strengthen further the insolvency resolution process, it has been considered necessary to provide for prohibition of certain persons from submitting a resolution plan who, on account of their antecedents, may adversely impact the credibility of the process under the code." End of quote. In fact, Ritu Singh joins me now with a special guest to take this conversation forward and to answer clarity with respect to fine print in that ordinance. Ritu, over to you.
Thank you for that, Kritika. We are, as you said, joined by, the man of the moment, Mr. MS Sahoo, who is the chairman of the Insolvency and Bankruptcy Board of India, at the very center of all of this debate. Mr. Sahoo, thank you very much for joining us on CNBC TV18. Let me dive right into the problem. A lot has been said about what the ordinance is really. Now, you've disqualified promoters on several criteria from bidding for their own companies. At this point, arguing the merits of the case, where they might say some of the problems related to the defaults and the reason why the company defaulted is outside of their control. It is because of the environment, it's because of supply or steel prices, etc. In this case, how do you justify keeping out those people from regaining control of their companies?
No, I think we are not trying to keep out any particular set of people. We are not talking about the existing promoters. We are only talking about the resolution applicants. So a promoter could be resolution applicant, somebody else also could be a resolution applicant. So we are focused on the antecedents of a resolution applicant, its promoters, its related parties. We are not focused on the promoters of a corporate debtors. If promoters of a corporate debtors meet the requirements of a resolution applicant, they are welcome. So absolutely there is nothing to say that promoters are not wanted. It is only told that the people who have the right credentials, they should come in.
So then would you then clarify on this point where you say anything, a lot of ambiguities around this point where you say the account, a person where the account is classified as a non-performing asset in accordance with the guidelines of Reserve Bank of India and for a period of 1 year or less where, if who has failed to make the payment on all overdue amounts and interest thereon, charges related to non-performing assets. So in this case, are you referring, to the promoter of that company or any promoter, that may have interest in another company bidding for this company where his own, say, company A had not defaulted in the first place? Could you please clarify? I mean, is this the promoter of the defaulting company or any promoter you're referring to here, which is the resolution applicant?
This requirement applies to resolution applicant.
Right.
If resolution applicant has any NPA on any bank,
right,
or any corporate debtor,
yeah.
So that means it's not limited only to promoter. If the resolution applicant has any NPA for 1 year, he is still welcome to do it if he clears the dues before he submits the resolution plan.
But, going by, the top 25% of the NPAs where most of these accounts are NPAs for more than a year, which effectively leaves out the promoters from bidding for these companies. Now, the counter argument here is, has the government done fair by these promoters by keeping them out when some of these circumstances were beyond their control? One. Two, does it not impact the price discovery of the asset when promoters were seen to be, one of the most aggressive bidders for these assets are now kept out? So it gives somewhat of a, an easier play for the other bidders that are looking to acquire these assets.
See, the very focus of this law is maximization of value of his assets of the corporate debtor.
Yeah.
We are talking about the company should continue to exist, should prosper, should serve the country in perpetuity. So our focus is that the corporate debtor should do well. That means it should end up in the hands of most deserving person.
So unfortunately, what the bankers have to say is that in some of the smaller cases, there may not be enough bidders. So by keeping out the promoter also, the company may actually end up in liquidation if no resolution applicant is found. So what do you have to say in that case? I mean, if a company is going into liquidation, jobs are lost and you're not really protecting the asset.
If a person is not that credible, even if you give it today, and you avoid liquidation today, it will end up in liquidation after 2 years, 3 years. So better you solve the problem from today itself. So the objective is the person who can really turn it around, who has capacity, capability, good track record. We should hand over the corporate in distress to that person, not just to any person.
But sir,
we are not. Yeah, please.
Sorry, sir. Do you not believe then, I understand your point, but will this not depress the bidding price of those assets if promoters or any one party is kept out by law?
I would not agree. See, two perspectives I would give you. Look at, let's say, capital market. Quite a large number of people have been debarred from market. Does it mean that the prices are subdued? Our market is so huge, there is so much of interest. I don't think prices will be subdued. Second is, if let's say you allow a person with this kind of credentials to take it over, where does he get resources? Will he get finance from banks? Can he raise money from a capital market? So if he is already not having good track record, who will give him money? So that means actually giving a corporate in the hands of such people means we are inviting sure disaster.
But sir, I would say this is somewhat of an Indian twist to the Insolvency and Bankruptcy Code. I mean, anywhere else in the world, have you seen a situation where, promoters of the company, in this case, which will be kept out because of some of the criteria that you've listed out very comprehensively in this ordinance, isn't it unusual from the what evidence we've seen elsewhere in the world?
First is, we need not have the exactly same as elsewhere. We have found out many indigenous solutions. Our IBC is not a copy of any of the models of US or UK.
Okay.
One. Second, there are instances, because in fact they do not talk about a promoter or non-promoter. Say US, if you talk about, they do not have this kind of promoter-dominated companies as much as we have. There they don't look at that way. There they say that if somebody is a fraudulent, he is definitely not allowed. There are many jurisdictions where a fraudulent person is denied to take it over. Nothing to do with promoter, non-promoter.
So, will you define what you call a promoter? Because in several of these cases, for instance, there may be a holding company that is a majority shareholder in a particular default case. In that case, the promoter of that holding company, would he be deemed as a promoter when he's looking to bid back for his asset, or how will you read that situation?
No, I think I would not be able to answer that offhand, but there are requirements of the connected person definition. One has to exactly examine whether that person is fits into the definition given there, that holding company, subsidiary company, related party. One has to apply mind in a specific case. The idea is that those who are in association with him, so you would expect if Mr. X is not okay, all his associates are also not okay.
So, but do you, just one final question before we let you go, sir, do you not anticipate some sort of a delay in resolution now because of this ordinance coming in retrospectively a few months into the IBC now coming into play? The 180-day deadline expires in January for most of these cases, and now is when IRPs and COC has to go back to the drawing board and re-examine the eligibility of all of the bidders. Do you not think this will push back the resolution and, also threaten liquidation for some companies?
No. As it is, they have 180 days time to complete the process, and there's a provision that in exceptional cases, 90 days additional time is available. And we have not reached a stage in any of these things except I'm told for Monet, there is the last day 26th of this month, and I'm told that has been extended. So in none of the cases, the timeline for receiving the submission of resolution plans had come. It is in the process of receiving. And they would receive by the time, and in any case, another 90 days is available. So I don't see much problem on time front.
All right, sir. Thank you very much for joining in, sir. Thank you very much for clarifying on some of those important points. And Kritika, I mean, clearly, one of the big ambiguous points was whether the resolution applicant, how the promoter itself is treated, and how, whether the promoter of another company that is not in defaulter can perhaps bid for these companies because he has not been an NPA for 1 year. In the case of Monitor Ispat, I just wanted to point out, because he brought up that case, that account was brought under SDR in August of 2015, which means because the SDR failed, it is only in April 1st of this year that he was technically classified as an NPA.
Yeah.
So will that be looked at retrospectively, and will he be called an NPA for more than 1 year or 2 years? So that is some, those are some important clarifications that are coming in. So clearly ruling out, at least in any of these 12 cases, that promoters will have any chance to bid for these companies.
Absolutely, and some important clarifications coming in over there. Thank you so much, Ritu, for taking us through that interesting interview. We'll have to take a very quick